This is the territory of the Haudenosaunee Nation on the west coast of Vancouver Island. The nation, along with the Gitxaala Nation on BC's north coast, launched a court case against the province's online mineral claim staking system. And today, a decision.
I'm actually very excited. I'm very excited. I'm very pleased with the decision and the ruling today.
Until 2024, it just took the click of a mouse and $25, and anyone could acquire a hectare of land from the province to explore and potentially extract provincially owned minerals.
Under the Mineral Tenure Act, anyone can stake a claim without consulting or notification. And we went to court, and they ruled that BC has a duty to consult. And so that kind of bought us a little time to negotiate with the province.
The ruling says BC's mineral claim system is at odds with the UN Declaration on the Rights of Indigenous People, or UNDRIP. It says BC law should be amended to incorporate UNDRIP immediately. Premier David Eby says the decision puts the courts in the driver's seat instead of British Columbians.
So I think it just as likely, or perhaps more likely, that we would proceed with amendments to provide clarity around what was clearly intended when we introduced this legislation, and the court appears to have some confusion about that.
Eby says his government will review the court decision and amend the legislation if necessary. Lawyers for the First Nations say they should be part of any discussions.
I think Premier Eby will find that as a result of today's decision, he has a legislative obligation to consult and cooperate with First Nations if he were considering amending this legislation.
Eby says the government could appeal to the Supreme Court of Canada, but would more likely amend the legislation.